Good morning, everybody. A very warm welcome to our fourth and final construction and engineering webinar of 2023, which is our winter update. My name is Stefan Harris-Wright. I'm a partner in the construction and engineering team at Birketts Solicitors. If we could have the next slide, please. So hopefully most of you will have heard of us before, but in case you haven't, there's some information at a glance up here on this slide for you and for you to have a look at afterwards, should you so wish. But in summary, we are a full service top 50 law firm. We've got 6 offices across the UK in the east of England, London and in Kent. And as part of our organisation, we have a specialist team of construction and engineering lawyers who advise on both transactional and contentious construction matters. If we could have the next slide, please. So I would like to take this opportunity to introduce you briefly to our speakers for this morning. So I'm joined by Emma Chiaramello, who's a senior associate in the construction engineering team. We have a bit of a guest speaker, a colleague from another team, that is Sacha Wooldridge. Sacha's a partner in our immigration practice. And also we've got with me Stephen Williams. Stephen's a solicitor in our construction engineering team, and he specialises in advising on construction disputes. So welcome to all of our panel. If we could have the next slide, please. So just to give you a brief summary of what it is we're going to cover in this morning's session. So Emma's going to provide an update on what is obviously a very continuing hot topic, which is the Building Safety Act. Sacha is going to give us an immigration law update with a perspective from the construction sector and how the work that she does impacts on clients in that space. And then Stephen's going to provide us with his usual update on recent interesting construction and engineering cases. And then we've got an opportunity at the end for a Q&A with the panel, who will all come back to hear your burning questions. So on that note, just a few housekeeping points. So there's some functionality within this GoToWebinar platform with a questions portal. So that's something which comes through to me, not to panelists or to delegates. So you will remain anonymous, so please don't be shy. Feel free to send those through. A good number of you have sent questions in advance, so many thanks for those. We'll do our best to get through as many of the sort of pre-submitted and live questions as we can. I will draw proceedings to a close promptly by midday, and also just to make you aware that the session's being recorded, so that will be circulated to delegates in the days after this event, along with a copy of the slides. If we could have the next slide, please. So without further ado, I would like to hand you over to Emma to kick us off with the Building Safety Act update. Emma.
Good morning, everyone. Thanks, Stefan. Next slide, please. So I'm going to be speaking about where we are currently with the Building Safety Act. As some of you may know, we had some updates in April and October of this year. Talking about briefly where it's come from, obviously we had the Grenfell tragedy, which really was born out of the market's failure to self-regulate, and the Building Safety Act is a big thumbs down from the government really in relation to that, and really driving greater and better thought through compliance with the building regulations. The Act itself received royal assent on 28th of April 2022. The government didn't fully comply with its own timetable, lots of other stuff going on, as you know, but really this is the biggest reform in building safety regulation for a generation. It's coming into force incrementally. So we've got recent changes bringing the bulk of the Building Safety Act mechanisms into force to the extent relevant to the construction industry. The main focus is on higher risk buildings, and in general terms that means anything 18 metres or more, 7 stories or more from the ground up, so not including basements, and that includes those high-rise buildings that fit within that category that have got more than one residential unit in them. And there are 12,500 multi-occupant buildings of that nature. really the big focus of the Building Safety Act is to emphasise that there are now Building Safety Act duty holders involved in all aspects of design and construction, and they have an obligation to take all reasonable steps to reduce the risk of fire spread or structural failure, and that's all reasonable steps, not just reasonable steps. Next slide, please. So as I've mentioned, it's the biggest change for a generation. It's a really ambitious piece of legislation. The Act itself is not a particularly easy read because it basically amends a lot of existing legislation, such as the Defective Premises Act, and it's been coming into force incrementally. The main changes recently have been the development of a new scheme in respect of high-risk buildings. The foundations were laid for that in April. The new duties and new terminology came into force, and the requirement to register existing high-risk buildings came into force, and they had to be registered by the 30th of September. From the 1st of October, it's actually against the law to have a high-risk building that's not registered. From the 1st of October, the Building Safety Regulator is starting its review of existing registered high-risk buildings and doing all its risk assessments. New offences have been brought into play. Registration for new build high-risk buildings is open, so you need to start registering those now. You've now got 3 gateways, which I'll talk about shortly. But basically, the Building Safety Regulator is now building control for all new build high-risk buildings. There's a new competency framework, which we'll talk about, and we'll have a talk about enforcement as well. And we use the phrase carrots and sticks, where the regulator is really focusing on encouraging compliance at the moment, but there are also some pretty big sticks in there to be mindful of too. Next slide, please. So the definition of high-risk buildings and the new scheme for high-risk buildings, it includes all works either to existing high-risk buildings or works to turn existing buildings into high-risk buildings, and works to existing high-risk buildings as well, and new build ones. It's really a move away from building regulations compliance as a tick box exercise, and a renewed focus in the industry on ensuring that you're documenting compliance and ensuring that everybody is properly trained and making all the right applications and really planning and managing the works as well. And any change management is really key. Bearing in mind as well that the Building Safety Regulator is effectively it is taking the form of the role of building control, and they will be coming to do on-site inspections, interventions, assessments of what further information may be required, and they will be heavily involved in any major change control processes. The regulator will set its own inspection schedule as well. So as I've mentioned, it's an offence from the 1st of October to allow occupation of an unregistered high-risk building. The review of registered high-risk buildings is starting. The new build high-risk buildings needs to start being registered, and building control is the Building Safety Regulator, which is overseeing all of that. Next slide, please. So focusing then on the 3 gateways, the planning gateway is the first one. You then need to arrange for the regulator to inspect pre-construction and again pre-occupation, and at each gateway you need to ensure your ducks are in a row really with the documents you've got together, and you need to be able to demonstrate that what you're building or what you've built complies with the building regulations. There are some transitional provisions for those buildings where you've got planning consent by the 1st of October and where you've made sufficient progress by April 2024. In that case, you don't need to go through gateways 2 and 3. Next slide, please. So duty holders, who are they? They are clients, designers, contractors, and all of them need to ensure they've got systems in place to ensure compliance with building regulations and that they're cooperating with all other duty holders, and that includes those that procure, plan, design, manage or build any buildings, not just higher risk buildings. So that role is very, very important in the construction industry generally. Also, we need to bear in mind that the definition of high risk building may change in the future. So this really is something to adopt as part of the course, I think, moving forward generally. One of the key things is that we're able to demonstrate both organisational and individual competency. So we have a new competency framework which is modelled on the CDM regulations. So the duty holders can perform duties under each set of rules. There is an industry competence committee which is being set up to prescribe requirements for competency, and there are some standards already in place as mentioned on the slide there. One of the key points to take away is that trainees and apprentices can't be duty holders. They're assessed as non-competent, so you must ensure they are supervised by someone who you can demonstrate is competent to perform that role. There's a lot of work being done on competency, and I think we can take some comfort from the fact that it's been modelled on the CDM regulation requirements. Bearing in mind as well, when you're making your building control approval applications in respect of buildings, we need to be able to demonstrate competency as part of those applications. Next slide, please. One of the terminologies used under the Building Safety Act is recognising residents as stakeholders in the building, you know, giving them a voice really, and giving them assurance that their building is safe to occupy. And really registration of a building does a lot for that, as does probably more so the assessment certification process, which is started on the 1st of October. The certificate arising out of that must be displayed in a prominent position in the building, and it's an offence not to do that. So need to give some thought to where those certificates are going to be displayed for the residents. Now, risk assessments by accountable person should already be underway. Setting up a risk management strategy and a practical plan. All of these things feed into the certification process, and we need to be demonstrating that they're being carried out. The accountable person needs to be creating its safety case report and logging and doing the mandatory occurrence reporting log for any specific occurrences that happen in regard to identified risks. Their requirements of certification as well. The accountable person also needs to consider engagement strategy duties in regard to, you know, speaking to stakeholders about how the building is being managed and maintained. Next slide, please. Moving on to enforcement. 1st of October saw a lot more powers of enforcement being bestowed upon the building safety regulator. They have a power of prosecution, and there's some hefty fines and risk of imprisonment as well if you're found to be in breach. It applies to all company officers, not just legal directors. It's probably unlikely that these powers will be used necessarily on day one. You know, we're still very much in the bedding in period, but the focus really needs to be on ensuring compliance, ensuring people are properly trained in compliance and that they're competent in order to make sure you don't get caught out with any of these things. Key focus at the moment is on education and guidance, and the building safety regulator is publishing a lot of that and arranging a lot of training and things like that, which you need to engage in, bearing in mind the sanctions that can be levied. Next slide, please. So what can we do to prepare? Just a few points here. I think a couple of my slides are missing, but I'll chat through what they say. We do need to analyse the impact of recent changes for our businesses, considering how it affects our people, their competency, what further training is required, the adequacy of our systems and data storage as well. Are we able to store all the data necessary to demonstrate compliance? I need to consider accountability within the organisations as well, to make sure that everybody takes their roles seriously and demonstrate behaviours which dovetail well with their performing their duties as duty holders. If we are doing construction work or developing land, we need to consider our ability to fulfil our duty holder role and consider our insurances as well. We need to ensure we're covered from all angles, bearing in mind that most people will require insurances to be maintained for 6 or 12 years, and we now have liability periods of 15, 30 years. So that's going to be a big change too. Really, key takeaway points are that understanding the new key definitions that we need to comply with and be mindful of. So duty holders, accountable persons, competency and stakeholders. This is the lingo really that we need to be masters of, and we need to be compliant, demonstrating our compliance. So some things we can do, we can ensure we're collating all the paperwork for the golden thread. We need to make sure we've got a regular process whereby that's reviewed and updated in a logical way, so that any gaps in knowledge needs to be identified and closed. We need to develop a strategy for dealing with that. Get third-party help if need be. Lots of consultants are able to help with things like that. There is a big focus on prioritising the highest risk buildings first and highest risk projects, so be mindful of that. With occupied high risk buildings, we need to ensure we've got an accountable person in place. There's adequate resident engagement. We need to be starting our risk assessments and communicating with stakeholders. Registration really is a huge priority, and the key point really is start work on it, show the regulator that you're taking steps to comply, demonstrating that all's in hand. That's the end of my section. I'm going to hand over to my colleague Sacha now, Sacha Wooldridge, who's going to be giving an update in regard to immigration. Thank you very much.
Thanks, Emma. That's great. Perfect. And thank you very much. Good morning, everyone. It's a pleasure to be here and to take a guest spot. So I want to talk to you today about recruitment and retention of international workers in the construction and engineering sector. We obviously know that this is a huge pressure in terms of recruitment at the moment. Your ability to deliver your projects on time and in budget depends on you having the right people with the right skills, and in particular, obviously, to meet all those requirements that Emma's just referenced going forward. So if we can just go on to the next slide, then I'd just like to talk you through really some kind of key developments. And some of these might be a little basic. We've moved on throughout the last couple of years since Brexit, but the COVID did hit our recruitment landscape a little bit. So by way of summary, I just really wanted to highlight that since Brexit, we have moved to that golden points-based system that was so often referred to in the press. And the benefit of that is that now all nationalities are subject to the same immigration process, the same work restrictions. So it's now one process for all international workers, regardless of where they have come from. In that respect, it makes it simpler to manage, but without a doubt, certainly more costly to be able to recruit workers where you're having to pay to sponsor them. And previously, you might otherwise have relied on freedom of movement for EU national workers. But really the key kind of mantra for the government is that the visas are tied to you as a sponsoring employer. And if you do sponsor a worker, they can only work for you and no one else, and only in the role that you've specifically hired them for. What people may not be aware of is that actually since Brexit, there is no longer a positive obligation for you to prioritise British nationals. So if you were aware previously, you weren't able to recruit international workers until you'd proven that there weren't any suitable British workers, which required at least a 1-month advertising process in days gone by. That is no longer a requirement, which should mean it's much quicker and easier for you to cherry pick people that you want to recruit and to bring them into your organisation and onto your projects. And also post-Brexit, actually, as the immigration ministers highlighted recently, actually the system is more liberal than ever before. Now far more roles are eligible for sponsorship. It used to be that you had to have someone operating at a degree level role, so typically probably engineers and project managers and above only. But now actually the ability to sponsor roles is much broader at lower skill levels, so RQF level 3, which is anyone operating at an A level or equivalent experience, can now be sponsored to obtain a visa and to come and work in the UK. Also, we've seen a focus from the government and a real push to try and help the sector to fill the roles and the vacancies that you have. So there is what we call a shortage occupation list, which is where the government recognise that there is just a real gap in terms of UK talent being able to fill these roles. So the shortage occupation list has since been revised. So this summer, it's now added bricklayers, roofers, carpenters, plasterers, and various other construction and building trades that you can now sponsor. So they're all listed on the screen there. Now, the benefit of them being listed on the shortage occupation list is that visa fees are a little cheaper, and actually at the moment you can actually pay a lower salary than is typically required for visa sponsorship if you want to recruit someone in any of those roles. Now, just to be very clear, a role does not have to be listed on the shortage occupation list to be able to sponsor. I say if it does, then if it is, then it just happens to have a few benefits. But in general, I just wanted people to be aware that it's much easier to sponsor international workers than previously. Okay, next slide, please. So I've mentioned the minimum skill level. The other thing I really wanted to mention, given it's a nuance of the construction sector, is that they must be your direct employee if you're going to sponsor the worker. So contractors are not people that you can sponsor as a UK-based organisation. And typically there's minimum salary levels of 26,200 per annum, unless there's a concession. Now, obviously in today's employee-led recruitment market, those salary levels are much more attainable than perhaps they have been in days gone by. And another thing you should be aware of is if you're sponsoring a visa, then that candidate must meet English language proficiency in all 4 facets, so speaking, reading, writing, and listening. Sometimes we see in the construction sector, potentially for the lower skilled roles, some of that being able to answer the nuance of the writing questions and the horrors of English grammar can be a challenge to that and to recruitment. But just so you're aware, that test is a mandatory requirement for you to be able to sponsor a visa. The next thing that I really wanted to mention is visa cost. So really, the UK immigration system has no caps on the number of sponsors of visas that you can sponsor, which is great, but it is incredibly expensive. So the UK system is one of the most expensive visa systems in the world. I've put some illustrated examples on the slide, but you're looking at about £6,500. That's going to rise to nearly £7,500 per worker from the new year. So it is really expensive. But then having said that, you know, you're paying recruitment costs anyway. If you've got that vacancy, it might be money well spent. But there are various things that you can do to manage those costs. And that might be that you as an organisation don't necessarily pay for all the elements of the visa process, or that you look to incorporate elements of the visa fees into an employment contract. And obviously, if you need support with that, then do take a further advice. Now, just moving on to the next slide, one thing I really wanted to focus on for the construction and engineering sector is really that the Home Office have got a bit of a bee in their bonnet about the sector. They pick certain industries that they consider high risk and at high risk of having illegal workers. This is particularly prominent where there are some lower skilled roles that have, you know, recently become eligible for sponsorship. So the Home Office take a little bit of a cautious approach. So really, I just wanted to share our experience that we've seen clients in this industry, particularly targeted by Home Office enforcement officials, which can include, you know, vans of immigration enforcement officers arriving on site unannounced. So really, it was just a reminder at this point to be focusing on that. Have you got a protocol? You know, what happens if immigration arrive on your construction site? Who does that get escalated to? Who's going to manage that process? Who do you call? I've definitely had clients report to me that, you know, suddenly workers are jumping the fence and running away, and it causes all sorts of aggravation. And actually, probably there wasn't a problem with most of them. So it's really worth having this at front of mind, and site managers in particular being briefed on how they would react in this situation, so you can manage it well. So the Home Office have doubled their enforcement capability in the last 12 months. So we are seeing now a return post-COVID to insight visits, but also to highlight that, you know, any organisations now is also being added to scrutiny by having phone interviews and remote audit requests, where the Home Office will contact businesses and say, look, provide us with your documentation. You've got 2 days to send this to you, or we may take further investigation. So that's just something that's really keen for you to note, and just to know that as an industry, you know, you're probably getting more scrutiny than other areas. Common issues that we see in particular is a lack of right to work checks, or right to work checks and really just not meeting an adequate format to provide you with the proper protection as an organisation. So really making sure you've got those really nailed down, and you're very clear on what the requirements are is essential to making sure that you can meet the demands of any Home Office audits, and to make sure you don't have any illegal workers, and to make sure you're not subject to penalties. Poor visa expiry tracking, again, is really common. Not so much typically where you're sponsoring the visa directly, but often where people have family visas or any other non-sponsored visa, we tend to see like common problems there. Also, as an industry, obviously, where you're being financed, if you've got changes in ownership or company structure, very often they're not adequately reported to the Home Office, and all those things are key. And the Home Office will use that to wrap your knuckles and potentially take enforcement action against you. So there's lots of reporting and record keeping requirements where you as an organisation sponsor visas. So failure to report that to the Home Office is really, it's a big no-no. And as if you fail in one area, they'll look at with a looking glass at everything else. So making sure you're really up to date on that is key. So if we go on to the next slide, what I wanted to really focus on is really that right to work checks are the easiest thing to get right, and also the easiest thing to get wrong. So I just wanted to highlight that, of course, that right to work checks are a mandatory obligation for all employees of your organisation. And there's been a real change in how that's done. So, you know, where people used to turn up with a physical passport and a physical visa document to have that checked, is really on its way out now. The Home Office are looking to digitise a lot of the right to work check process. And I really wanted to highlight that actually going forward from this year, only a digital check is deemed to be acceptable by the Home Office for any non-British or Irish nationals. So if you're recruiting EU workers that have got a Brexit status under the EU settlement scheme, or if they have visas, spouse visas, student visas, graduate visas, sponsored visas, any of those things, right to work checks are now digital. And if you're not doing right to work checks in a digital format for new hires, then you won't necessarily have a statutory excuse if you were to be found to have an illegal worker for any reason. So I just really wanted to highlight that landscape is changing. And in particular, also, I'd say more and more organisations are becoming approved visa sponsors. It's just the name of the game, where we used to rely on EU workers and they now all need visas. So one of the things that I did want to highlight whilst I had the opportunity was that naturally you would only undertake a right to work check for someone who was your employee. And obviously in your industry, there's lots of contractors that don't necessarily work for you directly. But I really wanted to highlight that the Home Office put specific guidance that if you are a Home Office approved sponsor for visas, they are obligating you and requesting that you do undertake right to work checks, even of contractors. Now, how you do that is really probably to be tailored on a business by business basis. And that might require you putting some due diligence on your contractors when you first engage with them, maybe having some interim checks throughout the lifetime of your contract with an organisation to make sure that they are meeting the requirement and the requisite standard, or just going full ball and doing a full right to work check on absolutely everybody that is coming on your site. And I think one of the most common problems I see in the construction industry is when the Home Office turn up on site to do an audit, there's often a sort of a confusion and a chaos while people try and work out, are you an employee? Are you a contractor? Now, obviously, from an employment law perspective, there's lots of discussion around worker status that is obviously key for national minimum wage requirements and the like. But I really wanted to highlight from a Home Office perspective, are you thinking about your right to work and making sure you're not creating any liability for yourselves there? So it's a tricky one. It's perhaps not your usual protocol, but it's just something that I would recommend reviewing, because say if you haven't got a correct right to work check, if the Home Office turn up, then the penalties are grave for non-compliance. So You can be charged up to £20,000 for every illegal worker that you have on your site. The reputational damage of having illegal workers is huge. So the Home Office proactively name and shame businesses that are subject to penalties for having illegal workers, and that often is probably worse for business than the fee themselves. So yeah, just something to really have a think about. Make sure you're not falling foul of that, and maybe just taking an opportunity to review your processes to make sure you're really comfortable. You know, I've had clients come to me and they've had the Home Office turn up on a construction site. They've ended up with a penalty of sort of £80,000 to £90,000 initially. And actually, when we reviewed it and sent back certain information and worked out who the employees were and who the contractors were, we were able to navigate that down to actually a zero penalty or a very small penalty, depending on the case in question. But that's a real ordeal, and it takes a lot of time for people that needs to be spent on, you know, doing business and getting things done. So don't fall foul of that, and take the time to proactively consider your processes, especially if your recruitment of international workers is increasing. So if you go on to the next slide then, just before I finish my section, I just wanted to very briefly talk about the policy landscape that we are operating in at the moment. Immigration law changes all the time, which obviously impacts you as a business and how you can sponsor international workers and recruit and find the right talent. So just a little bit of detail on that. If we go to the next slide. This is something that I follow quite closely, and I attended both the political party conferences earlier last month, just to really get a view of what's going on in government. Now, it'll be no surprise to anyone that's watching the news every day that immigration is a real hot topic. Obviously, we had a change in Home Secretary yesterday, who was very specifically targeted and mandating a reduction in immigration to the UK. So that then plays out, not only obviously there's a focus on the illegal migration and the boats in the channel, but that plays out into legal migration policy and policy for workers. So the current government are looking at reducing the ability for workers and individuals to bring accompanying family members to the UK. If those rules change, it might be harder to recruit, because not everybody will obviously want to relocate to the UK without family. The main one that I see changing imminently is that at the moment, as I mentioned earlier in the slides, if the roles that you're recruiting for, and lots of the construction and engineering roles are on the shortage occupation list, at the moment you've got the benefit of having a reduced salary that you can pay before being eligible for sponsorship. And both the current government and Labour, when I was at their party conference, were in agreement that they didn't feel that that was a good policy, because it was seen to be driving down standards overall and across the board. So I would expect imminently, and probably in the new year, for that salary concession for shortage occupation list roles to be removed. There was generally at the Conservative Party conference concern around the number of people coming into the UK, and specifically the lower skilled roles, the RQF level 3, the bricklaying, the plumbers, the traditional roles that we might see British apprentices filling in the long term. There was a question about whether or not it was suitable for those roles to be sponsored for work visas. So that might be reviewed in due course, but at the moment, whether or not that's a priority or that the Home Office have got capacity to consider that policy, it's hard to say. I think I would be confident, however, that visa costs will continue to increase. That's the main mechanism that the government have available to them to reduce appetite to sponsor workers into the country, is by making it incredibly expensive. And I think we will also see a sustained use of sponsor-led visa solutions, which is fine in the main, but certainly in industries where there's lots of self-employed people or contractors, if they aren't an employee and don't have a sponsor, it can be very difficult for those individuals to have the right to come and work in the UK. So that's something just to consider and bear in mind. I obviously mentioned the Labour Party. I think there's a general consensus in the polls and the data analysis that maybe we'll see a change in government and election next year. If that's the case, what are we expecting to see from Labour? Well, as I say, there was agreement that generally shortage occupation list roles shouldn't get any salary concessions. That's probably not a big concern anymore, given that the sort of wages that employees are commanding these days. But what I think we will probably see is that, given that Labour have made a very big policy that they will be supporting house building, you know, the shovels in the ground rhetoric, I would actually be surprised if they were willing to remove roles as being eligible for sponsorship going forward, because obviously that's just not going to help the sector deliver on that target for the government. So I think we would probably see a more liberal response and less focus on reducing immigration under Labour. But obviously it's hard to say, because obviously there is generally an agreement from the public that there needs to be better control over that. But at that, I'm going to stop, and then I'm going to hand over to Stephen, who's going to give us the case law update.
Thank you very much, Sacha. That was a fascinating insight and forecast on what is a really hot topic, as you say. Good morning, everyone. This morning I'll be talking to you about some 3 interesting cases. In these cases, I'll be covering concurrent adjudications, i.e. more than one adjudication at any one time, and a pitfall to avoid, resisting the enforcement of an adjudicated decision, particularly where you're trying to argue the dispute was too complex for adjudication, and I'll also be briefly covering payment terms. So if we move on to my first slide of my talk. This is the case of Henry Construction and Alu Fix. Now, it's all about adjudication. I could do a whole slot on adjudication in itself, but by way of a brief intro to those who are unfamiliar, adjudication is the most popular way of resolving construction disputes. This is in part owing to the fact that it's a swift process in comparison to court and arbitration proceedings. And it means that sometimes it's somewhat rough and ready, particularly in comparison to court litigation. But in my view, adjudication is fantastic for the industry, as it means as it achieves a swift outcome, whether that's right or wrong. But once the adjudicator decides the dispute, which is almost always decided on the papers, the decision can be enforced at court via a summary process. There are limited grounds in which you can dispute an adjudication decision during the summary enforcement process. One of those is the adjudicator lacked jurisdiction. I mentioned this because it features in the cases I'm talking about. Adjudication decisions are temporarily binding, so you have to comply with them. But if you're unhappy with the result, you can later try to seek a different outcome at court. So, without further ado, this first case involves concurrent adjudications. And as you'll see, the subcontractor, Alu Fix, started what's called a smash and grab adjudication. That's the colloquial phrase, a colloquial saying smash and grab. But a smash and grab scenario might occur where a party seeking payment submits a valid payment application and the paying party fails to serve a timely, valid payment/pay less notice. The sum then applied for by the party seeking payment becomes due, irrespective of the true value of the works. And indeed, that was what happened in the Henry and Alu Fix adjudication. So Alu Fix started a smash and grab adjudication. And before that adjudication was concluded, Henry, the contractor, commenced a true value adjudication. Now, submissions were made in the true value adjudication that the notified sum has not been paid, which is the $250,000 sum you can see at the first point of the slide. And Mr. Malloy, conscious of jurisdictional challenges, stayed the adjudication until the notified sum was paid, the $250,000. Once that was paid, he recommenced the adjudication. He ultimately decided that Henry had been AF had been overpaid. He decided in Henry's favour. Henry then sought to enforce that decision via the summary judgment process, the enforcement process. Alu Fix resisted enforcement on the basis that a valuation adjudication had been commenced before the notified sum had been paid, which is settled law as something that you shouldn't be doing. You need to settle the notified sum before you take other steps, such as commencing a subsequent adjudication. If we can go over to the next slide, please. Now, Henry's barrister tried to make submissions that Well, there was a substantial dispute in the smash and grab adjudication concerning the validity of the pay less notice. Therefore, the sum due hadn't been decided yet. The court ultimately was not convinced by that argument at all. The court said that the final date for payment had passed and the sum due was therefore due at the final date of payment. As a result, Henry was not entitled to start a true value adjudication until it had paid the notified sum. So this follows the principle of pay now and argue later, but it reestablishes what is settled law, that you cannot commence a true value adjudication in circumstances where there's an outstanding notified sum. That's a principle that's settled now, and this case is a reminder of that. And with that, I'll move over to my second slide, please. Thank you. The case of Home Group and MP Housing Limited demonstrates the difficulty of seeking to resist enforcement of an adjudication decision based on the complexity of the dispute, for one, and also the time constraints involved in the adjudication process. So let's take a look at some of the key points of this case. Home Group had commenced an adjudication following MPS's repudiatory breach of contract, claiming 8.3 million, which is, it's a fairly large sum. MPS had complained that the adjudicator lacked jurisdiction because the dispute was too large and too complicated for adjudication, and MPS said it didn't have sufficient time to prepare. The case involved thousands of documents and hundreds of pages of expert evidence, which had numerous appendices, subfolders. By all accounts, it was a rather mammoth adjudication. There was also a question of fairness, as Home Group, the party bringing the adjudication, the Home Group's expert had 9 months to prepare its report, which rather put MPS's expert on the back foot, because when adjudications commence, there's a very short window within 28 days, unless that's extended, for the party to prepare all of its submissions and provide its evidence, and for the adjudicator to make his or her decision. So it put MPS's expert on the back foot. He said he would have needed 10 weeks, where he had really a matter of days or a couple of weeks at most. So it was a real challenge for MPS. So let's see on enforcement how the court answered those questions of fairness based on the complexity and the time allowed for preparing a response. If we can move over to the next slide, please. So the court started with the principle that any dispute under a construction contract may be referred to adjudication. And complexity and constraint of time to respond are inherent in the process of adjudication and are no bar in themselves to adjudication enforcement. So while I empathise with the view that disputes often involve time constraints, that is just the nature of adjudication sometimes. Construction disputes are often complex, complicated, and involve numerous documents, sometimes thousands, that need to be organised and dealt with appropriately in order to reach for the adjudicator to reach a decision. The process is designed to arrive at swift decisions, to break deadlocks on construction process, and the court in this case is really emphasising that what is important is that the adjudicator feels that he or she can deliver broad justice to the parties, and that the adjudicator bears this in mind throughout the entire process. This is because adjudication is designed to get swift decisions rather than the right decision, and if you disagree with it, as I mentioned earlier, you can always go to court later in order to get a final decision or the true position from the court or the arbitrator's perspective. So what can you do if you're faced with a very, very complicated, complex dispute, or you think you're going to, an adjudication is going to be commenced against you? I think the key point here is to get advice as soon as possible. The earlier you engage someone, the more time you'll have to prepare, and once the adjudication is commenced, you'll be in better position if you've instructed someone early. And once the adjudication is underway, time is severely limited. So get onto it early. Someone who specialises in construction disputes, and that person may also be able to help you avoid those disputes too. And if we could please move over to our final slide, please. The case of Lidl and 3CL involved the court deciding on on payment terms in a contract. So Lidl engaged 3CL under a framework agreement. The agreement provided for interim applications to be made after defined milestones were achieved, which is fairly common. Now, the first red flag to note here from a payment term perspective is that the final date for payment was dependent upon the delivery of a VAT invoice. This is generally not permitted. You should not be tagging your final date to anything other than the due date. EC3L had made an application for payment in the sum of 781,000, just shy of 800,000, which Lidl valued at nil on the basis that the final date had not been fixed because a VAT invoice had not been provided. The adjudicator awarded the sum claimed, and 3CL subsequently commenced enforcement proceedings. As part of those enforcement proceedings, Lidl sought declarations regarding the payment provisions. In particular, that payment provision I mentioned earlier about the final date being hinged to the delivery of a VAT invoice. And if we go over to the next slide, we can see the rather conclusive position of the court, and that is that any payment provision which makes the final date for payment conditional upon any further event is invalid. The Construction Act was intended to introduce a blanket prohibition on party autonomy as regards to the ascertainment of the final date for payment, save as to the length of the period. The final date is decided by reference to the due date, and there is no scope for this to be determined by reference to any other event. So the key takeaway here is ensure your payment terms are compliant with the Construction Act, and if you are looking to ask for any sort of information to be provided with your application with applications, that's okay, but don't link the final date to anything other than the due date. Otherwise, the court will find that the provision is invalid, which could cause you problems down the line. With that, I'll hand over back to Stefan Harris-Wright, who will lead the Q&A. Thank you very much for listening, folks.
Thanks very much, Stephen. So hopefully we'll see all of our panel members returning to the screen. Here they all are. Excellent. Good stuff. Well, thanks very much to the panel for their very interesting presentations and also for their impeccable timekeeping. We've got a very healthy 10 minutes or so now to have a look at some questions. So I, without further ado, will launch into those. And Emma, if I can come to you first, please, on the subject of the Building Safety Act. Question here, please can you clarify the definition of a high-risk building?
Yes, as I mentioned, in general terms, it's 18 metres or 7 stories. That's from the ground up, so basement's not included. There's a bit of a distinction between the definition for a design and construction context compared to the occupation phase. It's not hugely different, but basically in design and construction, it would include care homes and hospitals, whereas in the occupation phase, it doesn't. It's obviously a policy decision, but hotels and barracks, etc., aren't included in that. So So in general terms, I'll come back to what I said, it's 18 metres or 7 stories at the moment, but it may change. Hopefully not, but it may do.
Good stuff. Watch this space. All right, thanks, Emma. Sacha, question for you, if I may.
Yeah.
And so the question here is, can a company or client that does not sponsor, but who uses contractors who do, be fined, essentially, I think is the nub of it.
Yeah, good question. So typically the Home Office would pursue the employer who they deem to be the employer. So generally speaking, my answer would be no. However, where the Home Office then undertake further investigation and view that you are complicit in that, so i.e. you perhaps knew what was going on, it was really a kind of sham arrangement that they were employed by a different entity, but you were really fully engaged and fully aware of what was going on, then I think absolutely there would be scrutiny and likely for them to also pursue you. At least they would come and probably do an audit on your own organisation to see the division between contractors and your own employees to further determine that. So generally speaking, no, but it's you know, once they find a flaw somewhere in the chain, they'll come at it with a fine-tooth comb. So one to be wary of for sure, and that's why contractor due diligence is key.
Very good, thank you, Sacha. Stephen, question here for you around smash and grabs. So can you ever commence a true value adjudication before a smash and grab adjudication has been concluded?
Thanks, Stefan. It's a good question. So as I mentioned earlier, it's established law that one cannot start a true value adjudication until the notified sum has been paid. Otherwise, your adjudicator will lack jurisdiction and the decision will ultimately be unenforceable. However, the Henry construction case did envisage that concurrent adjudications might be permissible in the circumstances we've just been discussing. For instance, the smash and grab adjudication might hinge on whether or not a pay less notice is valid. And if the court decides that the pay less notice was valid and it values the work at nil, then there was no notified sum. That sum was nil. So a concurrent adjudication would be permissible. But I think that would be rather risky because you're then hoping that the adjudication goes your way for the reasons I've just described. So it's risky in those circumstances, and it always turns on each case turns on its own facts. So do take advice, but it's quite common to have concurrent adjudications on multiple issues because that's the nature of construction disputes.
Very good, thank you, Stephen. Emma, I'll come back to you. Question here, which is, what are building liability orders and remediation orders?
Yeah, so building liability orders are really the mechanisms we've got. It's a High Court, it's an order that can only be made by the High Court, and it's aimed at special purpose vehicles, really, developers, and it basically extends their liability to sister and parent companies in circumstances where there's liability. In theory, it would be under both the Defective Premises Act and the Building Safety Act, Section 38, but Section 38 is not actually enforced yet. So at the moment, it would just be extending liability under the Defective Premises Act, but watch this space because it may encompass Section 38 in due course, and that means basically the obligation to comply with building regulations is under Section 38, and the Defective Premises Act is what contains the obligation to provide habitable dwellings. So there's a lot of overlap there probably, but yeah, that does pierce the corporate veil. There's another edge to that. It's a bit of a double-edged sword because the High Court can order disclosure of information where that information is not publicly available about who the parent and sister companies are. So be mindful of that too. In regards to remediation orders, shouldn't be confused with building liability orders, and that's really orders against landlords who in turn can seek contributions from developers and their associates too. And it applies to relevant defects, so basically fire, safety or structural ones, and it applies to 11 metres or 5 stories plus buildings, not just the high risk buildings. There is a new developer pledge that's been introduced by the government, whereby some of the big developers are going around with big remedial schemes, and that's the idea of that is both for PR and also to avoid the courts being clogged up with those sorts of applications. The first remediation order was actually made in September, so it's real.
Very good, thank you, Emma. Sacha, I'll come back to you. Question here, which is what alternatives are there to visa sponsorship, and can workers get their own visas?
So as I kind of mentioned, the current government really do like a sponsor-led system. So at the moment, that's typically the employer sponsoring the visa, an education institution sponsoring a visa, or a family member. Beyond that, there are very few visa categories that would enable someone to come into the UK independently. You would have to look at their circumstances. If they're younger and they're from certain countries, there is a youth mobility visa that's available to them, for example. And we're starting to sign, as part of our trade deals, more agreements now. So Uruguay, for example, was signed in the summer, which will give a certain capacity to nationals that are under the age of 30, typically 35 in some instances, to come to the UK without sponsorship and work for a few years. Similarly, graduates will have a non-sponsored visa that will enable work without restriction. Beyond that, you're looking at either someone's heritage to see if they've got any British ancestry, or their family connections. So if they've got a spouse or any contingent family in the UK, they can make a visa application in connection with. But other than that, sadly, there's not just a visa that you can say, look, I'd like to come to the UK and work for a couple of years. It's quite a tight system at the moment, so not generally.
Great, thank you, Sacha. We've got a few minutes left, so I'll rattle through as many as I can. Back to you, please, Stephen. Question here: are there any construction disputes unsuitable for adjudication?
A good question again. Construction disputes are often complex, and adjudication carries with it, inherent time constraints. So I think there will be some disputes that aren't suitable for adjudication. But I mean, from the adjudicator's perspective, the case law is clear that the adjudicator should be clear in his or her mind that they can do broad justice, and keep that question in mind. And if the adjudicator feels that they can't do broad justice, that's the point in which the court would expect the adjudicator to resign. Some claims will be so enormous, some adjudications so enormous and complex that maybe it's not the appropriate forum. But look at the case we were discussing earlier, 8.3 million, an 8.3 million pound claim involving thousands of documents, and that didn't reach the threshold. So the threshold is particularly high. But from the referring party's perspective, that's the party who's really in control of whether to take its adjudication or some other forum. Deciding on whether to adjudicate really depends on your strategy. You may require certain things in the court, the court procedure, such as disclosure in order to resolve the dispute. So, like always, it depends on all of the elements and issues in play. But yeah, I think there will be some that aren't suitable, or rather that would be more suited to court proceedings.
Very good, thank you, Stephen. We're almost out of time, but somebody has come up with a question that's very topical. So Sacha, I will come back to you. It's an interesting one here. So with a change in Home Secretary yesterday, will this mean any changes? Obviously, somebody's been watching the news and seen about Mr. Cameron's comeback.
Yeah, good question. So James Cleverly's position as the new Home Secretary, his view on immigration, there's very little that I can see well reported on this. He tends to be, from what I gather, obviously from his experience as Foreign Secretary, quite pro doing trade deals and is more open, I think, to allowing immigration to be part of that. So as an example, our trade deal with India has stalled a little bit because India would prefer a greater migration provision into the UK than currently, or under the previous Home Secretary, we were willing to concede on. So we may see more of that. Overall, though, obviously we're potentially looking at a May election as the latest intel from yesterday. If that's the case, there just isn't going to be time to put any significant changes in. So I imagine we will stay on course with the current policy provisions that we've got. And I think any significant change is only going to come post general election.
Very good, and forgive me for getting my Home Secretary and my Foreign Secretary mixed up, but that's interesting. Thank you very much, Sacha. Good stuff. Okay, well, we have come up to midday, so I will draw things to a close. That's all we have time for, but I hope you found this morning's session useful. When the session ends, you'll be asked to submit your feedback, including suggestions for things that you would like to hear from us about on future webinars. So if you've got a minute or two to just fill in your thoughts on what you might want us to cover on future events, that would be very much appreciated. That's always really useful. Looking ahead, we're in the process of finalising the dates for our 2024 webinar series, and so those will be publicised through all the usual channels in due course, so please do look out for those. So all that remains for me to say is thank you very much once again for joining us. Have a good day, and we look forward to seeing you next time.
Thank you.